Welcome back. Well, that was quick. Thank you all so much. Hope I had a nice week so far. Midterms. No one has come to see me yet, which makes me very sad. None of you. I was hoping some of you would, but not yet. I was here till about 6 o'clock on Tuesday. No one came by. I'll be here probably today till about maybe 3:30 or 4, give or take, if you want to come by. Otherwise, I'll be here tomorrow most of the day. I'll be here tomorrow probably starting around 10. I have a thing at noon and a thing at 3. But I'll be here more or less between 10 and 3 with I have a thing at noon. You don't need to email me. You don't need to make an appointment. Just show up. You might have to wait because there might be other people. Please print it out. If you can't come today or tomorrow, I am putting a deadline because I didn't think I'd have to, but I think I have to now. November 8th. You have to come see me by the 8th of November. If you don't, you forever hold your peace. So I'll be here tomorrow most of the day. I'll be here today till probably about, around 3 or so, or 3:30. That's this week. Next week, I'll be here also on Friday, and I'll keep my office hours as usual. Friday the 25th, I'll be around all day. That's actually the investiture of Dean Barry, the new dean. If you want to come on Friday the 25th, you should come to that. I think it'll be nice. It's like it's a big deal. They have all the ceremony. It's like a graduation for the dean. It's like everyone's in their robes. It's like a thing. I don't know. So come by Friday 25th. Friday the 1st, I'll be out of town, but I'll be here Friday the 8th. That'll be your last day to hold your peace. Okay. Your hand was up. Did I answer it? I knew I would. Thank you. You're welcome. But please, before you come, carefully look over the A+ answer and carefully look over the memo. I think that'll answer like 90% of your questions, but I'd be happy to come talk. The way these meetings usually work is you come in, we chat for a bit. I try and see who you are. I don't know you, most of you by now. Get to see how your first semester went, how your first year went. Then I'll look over your paper. I won't give you a grade like an A, B, or C. What I'll try and do is give you a range of this is like a 7 answer, or this might be an 8 answer. It's hard for me to give you a grade because of the curve. It varies every year what the grades become, but I'll try and give you a range like, well, this is in the B range, or this is in the A range, or this is the D range. I'll try to give you a sense of where you are, which is a rough estimate. I'll also tell you what you sort of missed. I'll give you some advice on your writing. I'll give you some advice on your organizational style. But for this to really work, you have to actually do the exam and take it seriously. If you don't do it, then it's a waste of time. But I'll at least get to know you and say hi, and we can chat for a bit. Usually take 15 or 20 minutes, not very long. So if you want longer, I'd be happy to sit. But most of them, that's usually how long they take. OK, any questions in the midterm? Yeah, I really wish I could actually make the midterm count. I think I've complained about this before. I wish I could make the midterm count as a percentage of your grade, even 10%, because I think that would change things significantly, but I'm not allowed to. The school's policy is that property is considered a 1L class, even though you're now in your second year of law school. That's the rules, and I'm stuck by them. Lots of rules we don't like, we follow. That's how most of the world works. We follow the rules anyway, because they're rules. Okay. Any questions? Okay. We are starting a new topic. We've spent the last, 2 weeks or so on the topic of what are called servitudes, right? Private servitudes, in which private landowners reach agreements to restrict the use of land. We talk about easements, and we talk about covenants. And with those easements and covenants, an issue is, how do you bind people down the road? That is, A and B agree to an arrangement today. How do you make sure that C and D, who come to picture later, are also bound by this easement or this covenant, right? And there are specific rules at common law of how to make covenants run with the land, right? But the next topic we're doing today is a little bit different, but it's similar, right? And think of this hypothetical. There are 10 houses in a block, and one of the houses decides to start polluting and building a factory on its property, right? The other 9 houses in the block are being burdened by it. Now, perhaps one way of eliminating that situation is if all 10 people on the block reach an arrangement, and they all agree to put covenants on their land to restrict commercial uses. Now that's expensive. That's time consuming. Okay, so maybe you try something else. Maybe you say, aha, we have a factory making smoke, let's sue for a nuisance, right? Boomer. And the Morgan case from North Carolina, right? We say that this property is polluting, and we seek an injunction. Or maybe you seek damage, depending on what the remedy is in your jurisdiction. But that takes time. Maybe the plant will be polluting for months or even years before you get to a final judgment. You have appeals, right? Those approaches are 2 ways to stopping something, right? You can reach a covenant to stop it before it happens, or you can sue for a nuisance to stop it after it happens. But it still revolves, I'm sorry, revolves not the right word. It still involves private citizens going to court, hiring lawyers on their own dime to stop stuff from happening, right? These are what we call private matters, right? A private nuisance suit. You're suing a polluter, right? A private nuisance, I'm sorry, a private covenant where the private parties are reaching these arrangements. Today we're starting something new, which is public land use regulation. If you think about it, everything you've done in this class to date has been private, right? There are no cases involving the government, right? In every single case you've done, it's been private individuals suing other private individuals. Zoning does something different. Zoning injects the state, the city, the county into land use decisions. Specifically, zoning shifts the burden, right? At common law, I could use my land however I wanted until court said stop, right? In other words, I would just build the damn factory and wait to get sued for a nuisance. Zoning flips it. Zoning says, we tell you what you can build before you dig, right? We designate what's feasible to construct here before you build it. And if you think about it, it shifts the burden, right? Now, there's no polluting factory because you can't build a factory in the first place. You need a permit to construct it, right? You don't have to wait for a neighbor to bring a nuisance suit because you can't build in the first place. Also, it minimizes the needs for servitudes like covenants, right? If an area is zoned for residential use only, you don't need to strike a covenant to restrict the land to residential use only, right? Zoning takes the place of private servitudes. Zoning eliminates the need to have these sorts of nuisance suits. Not always, you still have nuisance, but it eliminates a lot of them, right? Also, courts are sometimes hesitant to enforce covenants. Sometimes courts are hesitant to give injunctions for nuisance cases. With zoning, you don't have that problem. Before you do something, right, before you use the land in an improper way, you need permission from the state. And if you don't have that permission, you can't build. And let me tell you, if you try building something without the right permitting, the state will stop you immediately. There's no doubt about it. There's no question you're getting an injunction stopping you. You might even get arrested or fined. Right? So zoning was a way of shifting how land use is developed. And it shifted in large part from private enforcement through covenant and nuisance actions to public enforcement through zoning boards, right? It changed the way land use regulation occurs. Everyone get that much, right? Right, and I'll mention this point briefly. Houston, we don't have a zoning code. We have a lot of nuisance suits. In fact, the Ashby high-rise, which I think I mentioned in class last week, I brought pictures today, right? You've seen these signs around by Rice Village. The Ashby high-rise suit was actually based on nuisance. It wasn't based on zoning, because in Houston we don't have zoning, but we have nuisance, right? So we have those laws still. Okay. Everyone with me? Okay. All right, so that sounds great, Josh. We should have a situation in which private landowners don't have to go to court, that they can rely on a government procedure to regulate how land is used. Isn't that awesome? But there's a risk. There's a concern, of course. We are now entering a phase of property that looks a lot like constitutional law. And in fact, in many schools, this topic is taught in common law. I don't think it should be, but there's a lot of common law here, so don't worry, you're in good hands. But it's going to look different, right? Why? When private parties want to reach an arrangement of how to use property, they can do whatever they want, right? There's no limitation if A and B reach a covenant, right? They can restrict the land however they wish, right? If A and B are in a nuisance suit, a judge can enforce a nuisance. There's not much of a problem. But there's a difference, right? If I reach an arrangement for a covenant with you, we're going to have money exchange, right? I'm going to pay you, you're going to get some benefit. When the government regulates, they don't pay, right? When the government designates an area for residential usage, and you say, no, no, never mind, I want to build a factory. Can you pay me because of the money I'm losing? Guess what? No, right? Or maybe you do get paid, right? The issue you have to think about in this topic is this, okay? How is the government regulating this property? Are they merely exercising their police power, right? The police power is the state's power to regulate the health, safety, welfare, and morals of the people. Health, safety, welfare, and morals of the people, right? If the state is exercising their police power, then there's no compensation that's to be provided. But if the state goes beyond their police power and they take your property, they got to pay. They got to provide compensation. The challenge in this class is to figure out which bucket are you in. Are you in the first bucket, where you have an exercise of the police power with no compensation required? Or are you in the second bucket, in which you have what's called a taking, in which compensation is required? That's basically the rest of the class. I'm only slightly exaggerating. The rest of the class is asking, are you exercising the police power? Or are you exercising a taking? And depending which bucket you fall into, you know the answer. All right, so let's do a poll question to sort of get us thinking, all right? Let's look at this question, please. It's true or false. The government can provide you, I'm sorry, not provide. The government can deprive you of your property without providing just compensation. The government can deprive you of the value of your property without providing just compensation. True or false? Okay. All right, let's see. We got about 50 people. Okay. Who am I up to? Who's next? Who's raising your hand? Okay, thank you, Grant. Grant, what do you think the answer is here?
True.
Okay. Why is the answer here true?
Kind of like how you were just saying, if they were to restrict activities of the land, if you were causing a nuisance, they could use police power.
Okay, so let's take a look at the Fifth Amendment, right? Which, did you do Fifth Amendment in common law? No? I'm hearing yes and no. All right, so some of the professors at South Texas do takings. I don't do it. I do it here, but it's good as well. The Fifth Amendment is a takings clause, and it says, "Nor shall private property be taken for public use without just compensation." Right? So just focus on the text of the clause for a minute, right? There are a couple things going on. First off, it applies to private property, right? Which establishes that the Constitution recognizes private property. Can the government take your property? Well, they can. But they can only do so for public use. They can't take it for private use, right? What does it mean for property to be taken for public use? Well, the court has said quite broadly, anything is public use, right? If you take property and you sell it to a corporation who will generate more taxes, that's a public use. We'll do a case called Kelo later this semester, but that's not for now. If property is taken, they have to give just compensation, right? That's automatic. If there's a taking, you require compensation. But the sentence here didn't say the government takes your property. My sentence was the government deprives you of the value of your property, right? The million-dollar question for the topic we have today, does depriving you of the value of your property amount to a taking, right? If the government takes your property, literally, they take it away from you. They take a bulldozer and demolish your house, right? They took your property. There's no question about this. What about when they let you keep your land, but they restrict how you can use it, such as in Euclid, right? You can keep your land, you keep Blackacre, you just can't build on it. You can't build the factory you want. You can't build a home you want, right? All right, so the answer to this question is true. Let's see how you guys did. Oh, very good, 80%. That's right, pretty good. All right, the answer here is true. That's correct. When you have, I'm sorry, this is 81%, thank you. When you have a land use regulation, you have to ask yourself, is this a taking? How do we know if it's a taking? And I apologize in advance. The answer is very unclear. The Supreme Court has adopted many tests to decide what a taking is. These tests are confusing, they're contradictory, and they don't all line up. We have a lot of tests for takings. If you notice, I have not mentioned the U.S. Supreme Court at all this semester, maybe once or twice. And I like that, right? The Supreme Court makes me teaching really hard because their tests never make sense. Right? I dump on New Jersey and California a lot, but I can explain those tests pretty easily, right? Supreme Court tests are not clear, especially in taking. So unfortunately, if you hated common law, you didn't like the U.S. Supreme Court, you're stuck with it for the rest of the semester. I'd rather not, but we're stuck with it. Okay? So your question is, are you engaging in a taking, or is this merely a regulation of property? Okay, any questions so far? Okay. Okay. Very good. All right, so let's start with the discussion for today and zoning. Zoning did not exist in the 1800s. It wasn't really a thing. It began to be adopted by governments in the early 20th century. And the idea of zoning was to designate certain areas for certain uses. So you would say this neighborhood is only residential, this neighborhood maybe is commercial, this neighborhood is agricultural, right? This one is basically industrial for, like, dumping waste, right? Whatever it happens to be. You would have the government slice up the map and divvy things up, right? That's what's often called use zoning. You also had restrictions on height. Houses had to be at least so many floors. Buildings cannot be taller than 10 stories, right? You had width dimensions, right? That any lot had to be a certain number of acres. And the thinking behind these laws was to prevent crowding, right? You now had a growing industrial population, a lot of people living in close quarters, and the idea was to spread things out and to prevent growth that was too quick. Now, as with all governments, people have limited knowledge, and governments don't always know the best way to use land, and very often they may craft a zoning regime that makes no sense. And very often they may craft a zoning regime that deprives people the value of their property. In the early 20th century, state courts found that zoning regimes were unconstitutional. State courts found that these were depriving people of their property without any due process of law. They were given no justification why their land was treated as residential or commercial. Then some state courts began to suggest that these zoning laws could give rise to takings claims. Right? That is, if the government wants to zone your land, they have to pay you for it. Can the government pay you for your land? Of course not. As a result, they just wouldn't zone. Therefore, the Euclid case was very important. Right? The Euclid case was extremely important because it was an important test for the Supreme Court. Would they uphold a zoning regime? If this case had come out the other way, zoning laws would have been unconstitutional nationwide. The fact that this case came out the way it did was very significant because it gave a green light, a blessing, to all the jurisdictions to adopt these sorts of codes. There was no more doubt about whether they were lawful. Everyone with me? All right, Elliot, I think you're next, right? Oh, I'm sorry, Zach. Okay. Zach, can you walk me through the 6 classes, or what are called 6 use districts, that were in the Euclid Code?
Yes. So U1 is just single-family dwellings, public parks, water towers, and reservoirs.
Uh-huh.
U2 is extended to 2-family dwellings. U3 is further extended to apartment houses, hotels, churches, schools, public libraries.
Uh-huh.
U4 is banks, offices, studios, telephone exchanges, fire and police stations, restaurants, theaters. U5 is billboards and advertising signs, warehouses, ice cream, and ice manufacturing.
Yeah, ice cream. Yeah, ice cream parlors. Yeah.
And U6 is extended to include plans for sewage disposal and production of gas, garbage, and incarceration, scrap iron, junk.
Crap. Yeah. Basically, yeah. The insane and feeble-minded, right?
Yeah.
Okay. Let me explain how this works. It's a little bit counterintuitive, right? Think of this like a pyramid, right? Where the most valuable land is on the top, right? The most valuable land is U1, which are single-family homes, which have at least 3 rooms and a basement, right? That's the top of the pyramid. In U1, you can only build single-family homes. You can't build an apartment, you can't build a factory, you can't build a waste plant, right? So at the very top of the pyramid, you only have U1, only single-family homes. The next level in the pyramid is U2, right, where you can build 2-family homes. But you can also build a 1-family home, right? The way it works is you can always go down, you can't go up. In land zoned as U2, you can build 1-family homes or 2-family homes. Everyone with me? All right, then you have U3. In U3, you have apartment houses, hotels, schools, and libraries. In this area, you can build apartments or 2-family homes or 1-family homes, right? Then you have U4, which begins commercial. You can build all the above. So the idea is, if you can have a one-family home, you are only surrounded by other one-family homes. But if you can only afford a two-family home, you might be surrounded by one family or two family. Right? If you can afford an apartment, well, then you can have a one family or two family around. But do you think people were building apartment homes in the same place as one family homes? No. Were people building two family homes in the same block as one family homes? No. The purpose of these codes was to separate, right? It was to keep, I'll say it bluntly, wealthier people who can afford one family homes in one area, and not quite so wealthy people who have two family homes in another area, and not so wealthy people who have apartments in another area, right? This is not like an unintended consequence. It's a design feature of zoning. You'll see this dynamic quite a bit this semester, right? In which decisions are made to increase property values. We want to keep property values high. Well, I mean, that means a couple things. One, it means that when you resell your house, you won't take a loss. But also means people who can't afford it will not be able to live there. Right? It's just that's how math works. So the zoning regimes generally stratify, right? Wealthier people in one area, middle class people in another area, poor people in another area. And that's by virtue of where you can build. Also, the city will not zone many places for U1. So there are very few places where you can even build these houses. And they may not zone many places for U3. So there aren't many places to build apartments. So based on how much land is allocated for each use, there may not be anywhere to even build apartment buildings in the jurisdiction. There's just no area zoned for U3. We'll do a case in a couple weeks, I think, called Mount Laurel. It's from New Jersey. And in that case, the plaintiffs actually argue that the refusal of the city to actually zone land for apartment, for low-income housing, was a violation of the state constitution. And we'll do a case like that in a week or two. Okay? Now, one final point. The most restrictive land was U1, one-family homes. Right? They generate the least revenue, right? Because you only have 4 people living there. It's a fairly, even if it's a big house, it's only one house on a big lot. Whereas if you put a factory or a warehouse, that could generate a lot of money, but you can't build it anywhere. Okay? Everyone with me? All right, Natalie, you want to give me the facts, please, in Euclid?
Yeah, so the appellee, he owned the tract of land, which was over U2, U3, and U6.
Okay.
And so he filed for an injunction to get the ordinance by the government removed because he said that his value wasn't as great because of the restrictions.
Okay, so specifically, Natalie, if you can tell me, how did he think that this zoning regime diminished the value of his land?
Well, he said that it attempts to restrict and control the lawful uses of appellee's land so as to confiscate and destroy a great part of its value that is being enforced in accordance with these terms. Prospective buyers of land for industrial, commercial, and residential users in the metropolitan district.
Okay, but he gave some dollar amounts, right? How did he say that the amount was decreased?
So for the market value for the
In other words, what would the land have been worth with or without the zoning ordinance?
So it says 10,000 per acre, which is the market value for domestic commercial development. But if the use be limited to residential purpose, then it would be not in excess of 2,500.
Very good. Okay, that's okay. Thank you. In other words, the value of his land was decreased significantly. Without the ordinance, it's $10,000 per acre, right? You can build industrial, you can build a factory, whatever you want. If you could only build residential on U2, for example, and U3, Then it goes down to $2,500 an acre. So he's losing $7,500 for every acre of his lot. And I have I found the Google map link if you want to actually look at what it looks like today. It's a pretty significant lot. The diagram I think doesn't the diagram doesn't explain it quite how large it is. It's basically this right here, right? See the railroad tracks over here, and that main road's there. It's this entire industrial park that's there. So I mean, this is a really big area. All right. Now it's zoned for all industrial, so I guess everything kind of worked out in the end. But at the time, it wasn't. At the time, the book gives you a clean diagram. It was chopped up in 3 divisions. The part facing the front of the road was U2. There was this very narrow sliver of U3. And there was this huge chunk in the back of U6. Mackenzie, let me ask you, does this division, this 3 divisions, make any sense?
If you wanted to segregate it, yes, but beyond that, not really.
But what could actually be built here, right? That you're basically having a small lot for apartment buildings.
I mean, nothing.
Yes.
It makes it so you don't really.
And would you really want to put 2-family houses a couple yards away from a commercial plant near the railroad?
No.
Right. This is irrational. It makes no freaking sense, right? I'm sure there was someone sitting in some government office that, I have an idea. 3, 2, 6, done, whatever it is, right? It doesn't make a lot of sense. And it renders the land largely useless, right? It's basically arbitrary. Euclid goes to court, and he argues that this land use policy makes no sense, and that it deprives him of his property without the due process of law. So he wanted the court to declare this policy unconstitutional. The district court, there's this great line. The district court says, what was it? This case is destined to go higher. So, it's a great line. So, when you have these cases, you're just the first stop on the railroad. So the judge's like, all right, I'm going to find this law unconstitutional, but this is going higher. And the case goes to the U.S. Supreme Court. Now, there's some backstory here that's sort of, sort of funny. Initially, the court was inclined to declare this unconstitutional. At this time, you had a fairly conservative Supreme Court. And during this time, the court found that some economic regulations were invalid, that they violated the due process clause. As the story goes, one of the lawyers for the realtors sent Justice Taft a letter. And he said, Mr. Chief Justice, I know we're late, but would you accept an amicus brief, what's called a friend of the court brief, out of time? Taft's like, yeah, sure, I can do that. And apparently that brief turned the court. And what was a 5-4 decision to declare the policy unconstitutional became a 6-3 decision to uphold it. And this letter basically convinced the conservative justices that zoning was a good idea. And you can see some hints of how they persuaded them in the opinion with the way they describe apartment buildings and things of that nature. In other words, unless you permit zoning, undesirable people will be living near you. And this is a way to keep people out and where they belong. So Matt, I want you to please walk me through the court's analysis in Euclid. The opinion was by Justice George Sutherland, who one of my favorite horsemen, actually. He was my favorite horseman, in fact. During this time, there were 4 conservative justices who consistently voted against progressive laws. They were called the 4 horsemen, like the 4 horsemen of the apocalypse. It was Justice Van Deventer, Justice Butler, Justice James McReynolds, and George Sutherland. But here, Sutherland went with the progressives. Yeah, go ahead, Mackenzie. Matt, sorry.
Be no, I guess, Fifth Amendment violation because of the rational basis for why the government did this.
Okay, very good. And use this phrase, rational basis. This is a term which I'm sure you studied in con law. But under modern constitutional law, the court asks not whether a law makes sense, right? Not whether it's a good law, but is there some rational basis on which the legislature acted And here they say there was such a basis. Now, what was the basis on which the legislature acted here?
Didn't they just defer to the government branches? Like they're not the court was not an expert to question why they made
You're right. The court deferred, but what was the interest the government asserted here of why they needed this policy? Right? Why did the government need this?
I'm not sure.
Ethan, why did the government need this policy? What was this policy serving? What interest was it accomplishing? This is the crux of the case. Why did the government have the zoning law? Did they just make it up for no reason? Why does zoning exist? This is not a hard question. This one I've said it. You don't need to know the reading. Why does zoning exist, Ethan? What purpose does it serve? Don't be so cynical. Why does the government want zoning? What's their justification? It's not a hard question. I'm not the only one sticking. What does zoning do, Ethan? What does zoning accomplish? What does U1 through U6 accomplish? What does that do?
Well, it restricts the use of the land so that I guess it works more efficiently for public works.
What's the effect of separating residential and commercial? What does that do?
Efficiency.
Well, beyond efficiency, what's it do when you have residential one place and commercial another place?
Segregation.
It's not in your book. Stop looking in your book. It's not in your book. What does it do when you separate residential and commercial? It's common sense.
Well,
It's not in your notes. Do you want to, wherever you live, do you want a factory being built across the street?
no.
Why not?
Well, because that would be a nuisance. It would interfere with my.
Yes, that was so hard. Separating the uses lets people live their lives in a clean fashion, right? It keeps residential and commercial apart, right? It allows the state to ensure people have space, that there's clean air, right? That there's green space, that you're not all congested, right? That's not insane, right? Now, does this actually accomplish that? Of course not, right? Does this regime actually ensure? No, you have a two-family house across the block from a factory, right? This is not accomplishing anything. This is completely irrational. But the court's review, what we call rational basis review, you remember from con law, doesn't scrutinize the justification. That if the reason given sounds good, okay, that's good enough, right? This is a rational justification. And the court defers to the government's decision of how to zone this land, right? Even though it diminishes the value by such a significant percentage, they don't move on. They don't set it aside, okay? Now I want to walk you through some of the language in the court's opinion, right? Again, this was written in the early 20th century. Cars were now a thing, right? People could now commute longer distances. You now had people maybe living in places they didn't used to live, right? It used to be the suburbs were very quiet, right? If you wanted to live in the dirty city of Cleveland, you lived in the city. But now you can live in a suburb of Cleveland and drive in. And with that, you brought all the congestion from the city, right? This is about keeping the city in the city, and making the suburbs peaceful and quiet. Right? So the court says a regulatory zoning ordinance, which would be clearly valid as applied to the great cities, might be invalid for rural communities, right? There might be a different standard. But we have to consider all the circumstances, right? The fact that a city is different from a county doesn't affect the analysis entirely. The court writes in a very famous line, a nuisance may be merely a right thing in the wrong place, like a pig in the parlor instead of a barnyard. How do you decide if a use is proper or not? The courts do not second guess. If the validity of the legislative classification for zoning purposes may be debatable, that people may debate it, may disagree, the legislative judgment must be allowed to control. Right? In other words, if this is an issue on which the legislature came to a conclusion, the courts will not second guess it. Some zoning restrictions make sense, right? Regulating the height, the methods of construction. These were used to restrict fire, right? Before you had fire departments like you have today, you could use zoning to prevent fires from catching. But here, the only thing challenged is not building materials, but excluding offensive uses from certain land. You have to be deferential and give the government give the government a margin of error. Okay. And ultimately, the court gives a test. Does a zoning ordinance bear a rational relationship to health and safety? Does a zoning ordinance bear a rational relationship to health and safety? Does it protect children? Always worry about children. Does it help people walking up here on the streets? Right? Does it maintain districts? Does it maintain property values? Right? These are all values of which are enough to uphold the zoning laws. Okay. Everyone with me? Morgan, does the court concern itself with the harm to the property owner here that his value now is, being cut by a quarter of value, 3/4 of value?
No, because there was nothing in the record to suggest that any actual damages resulted.
Yeah, it's kind of a weird thing, right? You know what the market value of your property is, but you don't actually get a firm number until you try to sell it. Now, the flip side is, who's going to buy this land? No one. So you're sort of in a trap, right? You can't prove your land's worthless because no one's going to buy it. And by the time you actually sell it, well, it's not yours anymore to bring to court. So you're basically stuck. Once the government decides your land is subject to the zoning ordinance under the regime, you can't challenge it. You're screwed, right? I suppose you can say that your remedy was to try and block it through the democratic process, but maybe you didn't have the support. The court also talks about these comprehensive reports, which come up over and over again, and painstaking consideration. Now, if you ask me, this was not very considered, but the court's not going to second guess it, right? The court says that the segregation of residential, business, industrial properties makes it easier to provide fire protection, increase safety, prevent accidents to children, reduce traffic, reduce noise. Which I think makes sense. But then they go on to talk about apartments, right? Jennifer, how do they, I'm sorry, is that, Ashley, I'm sorry, I said the wrong name. No, I had a mental lapse, I'm sorry. Ashley, how How does the court discuss apartments? This is one of the more memorable parts of the decision.
Oh, they describe them as a mere parasite.
A parasite, my goodness, right? Why is an apartment a parasite?
So it's taking advantage of the open spaces and
Yeah.
surroundings.
Yeah.
Changing the character of the district.
Yeah, very good. Okay, so a few things, right? First off, the idea of an apartment building is somewhat novel for fairly mundane reasons. Building up was hard when all you had was stone and wood, right? In order to build up, you need concrete, you need steel, you need various materials that allow you to build high rises. That just didn't exist. So the idea of putting a lot of people in the space where one family used to live was very offensive to the justices, right? It was very offensive that you would pack in however many people, however many families into apartment complex where maybe you had 1 or 2 families before. And I think they basically say that the apartment house is a parasite. A parasite. Think of like a tick, right? A parasite constructed to take advantage of the open spaces and attractive surroundings created by the residential character of the district. Okay, this is where the ball game is, right? There's no, they're not hiding it, right? They're basically saying we don't want poor people coming to live in the suburbs. If you tell me I'm wrong, that's fine, but that's pretty blunt. And the power of Euclid was not about screwing over the business owner. That, I guess, was sort of incidental. But the important part was U1. And what you'll find is in many districts, almost everything is zoned U1, right? Almost all the land is U1, which means only one-family homes can be built. And that means only the people who can afford one-family homes can live there, right? You'll see this very clearly in other cases. They say that apartments block sunlight, they block air, they create noises, and they destroy the character. Maybe apartment houses are desirable for cities where you have to go up, there's not much space, but not nearly as valuable in more rural communities. Ultimately, the court upholds this as a reasonable regulation of property. Okay. All right. Any questions so far? All right. But the court doesn't slam shut the door entirely. The court says, well, look, as a general matter, zoning laws may be valid, but there could be cases where a specific zoning scheme is irrational, right? There might be specific instances where a ordinance makes no sense in a particular case, right? This is the difference between a facial and as-applied challenge. A facial and as-applied challenge. You may have seen these phrases in con law. A facial challenge is when a person challenges a law on its face. That they say every element of this statute, right? Every element of this law is unconstitutional. That this statute can never be valid. It's so irrational. Those are hard to win. Those challenges. Facial challenges are hard to win because there can always be a circumstance where the statute is constitutional. But there's a second type of challenge, which is called as applied, where you say, look, as a general matter, this zoning law is okay, but what they did here is bizarre, right? I mean, I actually think that the court could have said the ordinance is valid, but this is completely irrational, right? Why would you put a little U3 here where there's no way to build an apartment building, right? It basically makes this land useless, right? Why would you zone land that's so small for something that has to be very big? But the court says this one is not arbitrary. But at least the court held open the possibility that a zoning regime may be arbitrary as applied to particular land, right? You know, let's say that there's land that's across the street from a waste dump, right? And they zone it as U1. Okay, no one's going to want to live across from a waste dump. That doesn't make any sense. Okay? But they don't decide that here. All they decide is, as a general matter, these zoning laws are valid. Yes, Stephen?
Do zoning laws directly affect the taxation of the property too?
Yes. So a couple things. If you don't know this already, property taxes are assessed based on the value of property, right? Every year the county appraises your land and decides how much it's worth. So land zoned for U1 will have more expensive houses, will generate more taxes, and give the county more money. That's not surprising then why counties want more U1 than U3. Because generally apartment complexes don't generate nearly as many taxes. But yes, good point. Okay, questions on the first case, Sutherland, I saw another Sutherland case this morning in Conlon. I'm sorry, that was called Atkins. This is a Euclid. A fun fact, the name of this case is very appropriate. Does anyone know who Euclid was? He was a father of Greek geometry, right? So this is a fitting case about, chopping up land in shapes and sizes. So the phrase you'll see is called Euclidean zoning, or Euclidean land use. You'll see it maybe different ways, right? Euclidean zoning. What is Euclidean zoning? Based on village of Euclid, right? That's where the case name comes from. Not very important, but you may see this in different uses. Okay, questions so far? All right. What happened after the case? Shocking, his land remained vacant, right? There was really nothing he could build there. Eventually, the land was rezoned for industrial all the way, and GM built a facility in the 70s. I'm sorry, built a facility during World War I or World War II, and it closed during the 70s. Today, if you just Google it, there's some sort of industrial park there. And I have a picture of it here, I think. Yeah, there's a Euclid industrial park. Paintball City, yeah, there you go. That sounds like fun. After Euclid was decided, zoning laws spread very quickly. I think 47 of the 48 states enacted zoning laws, and almost every county in the country has it. And in some places, the 6 use districts were expanded to as many as 20 use districts. So it became extremely complicated to comply with. Okay, everyone with me? All right, I'll move on to the next topic. How does zoning authority work? All right, now let me take a step back. We live in Texas, right? Texas is a state. Texas has authority, what we call the police power. We live in the city of Houston, right? Maybe you live in the city of Katy, maybe you live somewhere else, right? What is a city? Huh? What is a county? Huh? You probably never thought about this, right? What is a city? A city is just a division of the state, right? The state of Texas decided to create the city of Houston, right? The state of Texas decided to create the city of Austin. In fact, there's a non-trivial move for Texas to abolish the city of Austin. Just abolish it for mismanagement. There's actually people, yeah. Austin's not in the best rates right now, so people are not happy with it. So just abolish it, right? But if they wanted to, you basically make it like a federal district, like the District of Columbia, have the state run the city. In other words, you abolish the mayor. This is going on now. Just walk around Austin for a bit, you'll see. Could Texas do that? Probably, right? If a state wanted, they could abolish a city, make it basically a district for the capital, which the governor runs. I think they could do it. Well, I'm sure there'd be a judge somewhere who stops it, but it could happen. Where then do cities get their authority from? Right? Cities get their authority from the states. Right? When Texas chartered Houston as a city, it delegated certain powers for the city to exercise on its own. Right? There are some things Texas can legislate on, and there are some things that the state lets Houston legislate on. Houston can't legislate on everything, right? Houston can enact certain laws, right? For example, in Texas, cities can enact gun control laws. They can't enact fracking bans, right? There are things that cities cannot do because they were not given the authority to do so, right? If a city tries to do something they don't have authority to, we say they lack delegation, right? They lack a delegation of authority, right? Again, if a city doesn't have the power, it's because the state did not delegate the requisite authority. And there's a Latin phrase, which you may have heard of, called ultra vires. You heard of this phrase? Ultra vires, right? Ultra vires means beyond the scope of authority. Right? If a city tries to take an action for which they don't have the authority, the action is ultra vires. Why does this matter? Because when Texas adopts a zoning law for the state, it gives the city some power, but not all powers. And occasionally, the local jurisdiction goes beyond the delegated authority, and therefore their actions ultra vires. So courts will then scrutinize with a zoning case, was this actually delegated authority? I'll give you an easy example, right? Let's say that the state tells Texas, you can regulate the height and the width of the buildings. Okay. But then the city of San Antonio says, we're going to regulate the building materials. The statute doesn't say you can do that. It only says height and width, not the materials. That would be an ultra vires zoning law, right? And if I owned a property in San Antonio, I could challenge it as a violation of the ultra vires doctrine, the delegation doctrine. Okay? We'll do some cases next class where this makes a little bit more sense. Yes, Stephen?
So in some situations you have unincorporated like townships and things like that too. Or in unincorporated counties you have townships that pop up.
Yeah.
Are those a lesser extent authority than a city?
I don't know if those places have zoning authority. They may not be. They may not have it. It may be the broader city. So Houston's weird, and I'll talk more about Houston later. But Houston's kind of unique in that it has no zoning code. But there are little pockets within Houston that do have zoning. So West U, for example, West University. If you go by I-10, all the villages, Hunter Creek, Piney Point, right? All these little villages, they're basically not in Houston. That's why they have pretty sidewalks, right? They have their own zoning boards, right? If you walk around West U, if you drive on Buffalo Speedway, no sidewalk, oh, sidewalk, right? Why? It's not part of Houston. They have their own zoning commission. So some of these little pockets have their own zoning boards, but I think it really varies. Yeah, that's why really just drive down Buffalo Speedway from 59, right? On one side, it's West U, and the other side, it's not. The West U side has sidewalks. The other side really doesn't have sidewalks because there's zoning laws about sidewalks. I know it sounds trivial, but you'll see it. I live in Houston. That's okay. I'm happy to have no zoning. Makes life easier. Okay, any questions for? Okay. All right, so here's how it's usually structured. Most cities have what are called planning commissions. And there are different names, but planning commission is a decent name. And these are people who come up with the zoning code, that this area is U1, this area is U5, whatever it happens to be. Generally, the people appointed to these commissions are regular citizens. They are not experts. Maybe they're architects, maybe they're lawyers, probably not. They're people who take a general interest in their community. Sometimes they're appointed by the mayor. Sometimes maybe the city council appoints them. They're different appointment paths. Okay. The commission can make certain decisions, right? Recommendations, but it's actually the city council that votes on this stuff, right? Appointed people can actually make law, right? So first you have this commission that comes up with this plan, and then usually the city council rubber stamps it. Okay. All right, what next? Okay, so there's a zoning plan in place, right, which says in this area it's only one family, in that area it's only two family. What if you don't like that? What if you want to do something different, right? There are two kinds of approaches you can take. The first approach is what's known as a variance. A variance. What's a variance? A variance means there's some hardship, right? There's a hardship that if you enforce a zoning law, there's something really bad that's going to happen to me. And at that point, you're basically asking for the government's mercy or discretion. Please exempt me from this rule. I have a hardship. There's another type of exemption, and we'll do these next week in more detail, but I want to introduce them now. There's another type of exemption, which is called a special exception. A special exception. In these cases, the legislature might say, well, you generally can't build a two-family home here, but if you make it a certain height and width, you can do it, right? Generally, you can't do it, but if you make a certain height and width, you can do it. If you meet those conditions, you get your special exception, right? It's automatic. There's no discretion. All right, so the biggest difference with a variance and a special exception is one of discretion. With a variance, it's based on your hardship. How sad? What kind of sob story do you have for the government? With a special exception, there are specific categories, and you have to meet them. And if you meet them, you get your exemption. Okay? All right, now, so what happens? You go to the zoning board, and you ask for a variance, and they say, sorry, Josh, we don't think you're sad enough. It's not hard enough. Or, you know, Josh, you're sorry, we're not feeling it today. You can appeal it. Most jurisdictions have what's called a Board of Zoning Appeals, a BZA, a Board of Zoning Appeals. The purpose of the Board of Zoning Appeals is to give a second look at it. Generally, these are deferential, right? The Board of Zoning Appeals generally will not overrule the zoning board. And what if you're unhappy with the Board of Zoning Appeals? At that point, you go to court, right? You can go to state court. Don't go to federal court. You go to state court, and you can challenge the zoning decision. Generally, courts are deferential. They do not second guess the zoning boards. We'll do a couple cases where they do, but as a general matter, if you lose in the zoning board, you're probably done. That's usually the end of the road for you. Okay. All right. Questions so far? Okay. I want to talk now for a bit about Houston, our lovely hometown. I think the most iconic image of Houston zoning law is by the Galleria with the Zona Erotique next door, which is basically a porn shop, which I think is closing soon. I read that somewhere. I can't imagine business exists without the internet. I don't know. Maybe I don't know. What do I know? But in no other city in the country would you have this, stop snickering, this ginormous, beautiful mall right next to a porn shop, right next to a gas station, right? The other image I always think of, if you drive down Dallas Street going downtown, you basically have one-family houses within a few blocks of skyscrapers, right? You don't see that anywhere else in the country. It just doesn't exist. If you just the proximity of the high-rise skyscrapers, like one-family houses sort of on the outskirts, like just so close, you don't see that anywhere else. So it's a remarkable thing in Houston. Houston City Charter, which is basically our Constitution, prohibits zoning, meaning the city council cannot enact zoning. The only way to revise that is through a popular referendum. We vote on referendums, right? There have been 3 referendums in the last century, in 1948, 1962, and 1993. The last one was actually close. And the referendums defeated it. They did not want to adopt zoning. And the reason why is people thought it would make their land more expensive, make it harder to live, which is generally true. Zoning increases costs. One of the reasons why Houston is so cheap to live in, let's put a house, right, is because we don't have zoning, which makes everything much more complicated. Now, Houston doesn't have any use zoning. That is, you can have a industrial complex across the street from residential homes. You see this all over the place, right? I used to live on Westheimer, and like within a 1-block radius were one-family homes, storage facilities, like restaurants, and like a hospital, right? Just urgent care centers. I mean, there was completely random places nearby, which I'm okay with, right? It makes it easier for me to go places. But there are downsides. I'm biased. I grew up in New York where everything's very structured. I like Houston. Oh, I shouldn't have said that about the game tonight. I'm sorry. I'm conflicted because I've actually become a Houston sports fan over the years. Like, I've been here almost 8 years. I used to be a Knicks fan, and I forget that. So now I follow the Rockets. It's just, they're so bad. They're just terrible. So I follow the Rockets now. I actually like them. But baseball, I root for the Astros unless they're playing the Yankees. So sorry. I was at the ALCS a couple years ago when Cray hit that home run. I was actually at that game. That was a good game. I was like, oh, damn it. Oh, yes, it's good. So like, I was very torn. But anyway, so I'll be watching tonight. But Houston has zoning without the Z word, right? It doesn't actually call it that. And there are many ways in which Houston has what Professor Festa calls a de facto zoning, what I call backdoor zoning, right? And I'll give you a couple of the ways. Houston has a minimum lot size. Okay. In other words, any lot must be at least 5,000 square feet. Okay. This rule only applies outside of 610, the 610 loop. It used to apply inside, but now it applies only outside the loop. What's the effect of this, right? It's very difficult to build, right, townhouses, right, adjoined townhouses on this sort of lot. If you have a one-family house, that's easy to build in 5,000 feet. But if you want to build a joint house, you probably need more. The effect of this, right, is that you have to actually spread things out, right? You could build a townhouse in a small amount of space, but there's a lot of land surrounding it. So lots become bigger. And when lots become bigger, it spreads things out, which requires more driving and reduces walkability. Okay? This has changed in the last 20 years because now inside 610 you can have smaller lot sizes, which is why we've loved sort of residential construction downtown. You see that as well. Another Houston regime is parking. You may not know this. The law requires for every one-bedroom apartment 1.3 parking spots. Right? That is, for every bedroom that's built, there has to be at least 1.3 parking spots, which means for every 3 bedrooms there are 10 parking. There are 6 parking spots. 4 parking spots. I can't count. Right? So the more people, the more parking spots, and parking spots take spaces. Right? There's a lot of room for parking lots. That's why in Houston the parking is very ample, and in New York City you can't park anywhere. In any sort of office building, for every 1,000 square feet, you need about 2 parking spots. This is my favorite. At a bar, for every 1,000 square feet, you need 10 parking spaces. So people driving to bars, which I guess makes lots of sense. I don't know, Uber, right? But in other words, the city has rules built in to ensure space is available for parking, to ensure there's enough people to drive places, because things are far apart. There's another one called an offset, which means space, where generally houses must be 25 feet from the street. Right? There has to be a lot of an offset, right, of space. But having that big offset also means sometimes sidewalks are smaller. There's less room for sidewalks because you have these wide streets, wide offsets, small sidewalks. That's why many places in Houston lack sidewalks. In Houston, sidewalks only have to be 4 feet in width, which is not very wide. You know, it's about maybe about this wide. So you have smaller sidewalks as well. I remember my parents, they first came to Houston to visit me, and they were staying by the Galleria. They tried to actually cross Westheimer by Post Oak. You know where that intersection is? You can't. It's just not. Maybe you can now. They sort of like changed a little, but they actually tried crossing from one side of the 610 to another. It was just, you can't do it. Yeah. Put your hand up? I thought that's my hand. Never mind. Sorry. Anyway. Also in Houston, blocks are very long. Most intersections are 600 feet apart, which means to make a turn, you have to walk all the way to the end and come around. You don't have smaller blocks. Smaller blocks promote walkability. If you ever go to most cities, they have fairly small blocks. Houston does not have any sort of code that separates residential and commercial usages. But they do have what you call are deed-restricted communities. You see these signs everywhere. Right? So a lot of land, though it's not zoned as residential, is deeded as residential. And private covenants are able to restrict it. But Houston's unique in one regard. The city can enforce private covenants, right? Let's say that land is zoned for residential use only, one-family homes, and the neighbors actually don't care about it. They'll say, oh, it's fine, build a 2-family house. The city can come in and sue to block the construction of land that violates the covenant. Now, wait a minute, Josh. How does a covenant give the city the power to enforce it? Isn't it just a covenant between A and B? Yes. Houston's very unique in that regard. I don't fully understand why it works that way, but the city does assert that power. Oh, highways, of course. There are lots of highways, but we know all about that. Okay. The upshot, though, is when you have a less restrictive zoning code, construction's cheaper. And the housing prices are a fraction in Houston for other comparable big cities. It's not even close. The house I bought in Houston would have been maybe 5 times as much in New York, and I've had an hour commute. I have a fairly short commute now. So it's a lovely thing if you don't mind the drive. Okay. Questions on that so far, on Houston? Yes, Stephen?
You said Festa called it de facto zoning. What did you call it?
I call it backdoor zoning, which sounds a little bit less legalese. What was that? I heard something. I heard something. I will pretend I didn't hear it. I have very good hearing. It's actually my deficit to hear everything, which is bad. Okay. Let me wrap up by talking about the Ashby situation, which I think I mentioned in class before. This has been the story of a story I tell in class every year for the last almost 8 years now. If you go to the Rice Village area, not too far from the Museum District, there's an intersection between Ashby and Bissonnet. If you drive past it, it's an empty lot. It's just this empty grass lot. There's a fence there. There's nothing constructed. Nearly a decade ago, developers proposed to build a high-rise, which, I don't know, looks nice. I don't know. It was mixed use with some shops on the bottom and a bunch of condos on top. They wanted to build this mixed-use facility in the Rice Village area, not too far from Rice University. I don't know, it looks nice enough. What do I know? The neighbors were not happy about it. The neighbors put up these signs throughout the entire area. You've seen these, right? Tower of Traffic and stopashbyhighrise.org. You can visit their website. And they very much did not want this in their community. Now, if this happened in any other city in the country, where someone wanted to build a residential high-rise in a one-family home neighborhood, it would have stopped immediately. Non-starter. Why? The zoning board would not have given a permit. They said, well, this is zoned for one-family homes. You want to build a high-rise? Sorry, go away. Apply for a variance? Denied. Right? The neighbors would not have had to do much. Right? The burden would have been on the property owner to seek a permit. But Houston's different. In Houston, once the developers own this land, they can start building. They didn't need a use permit to construct. So the neighbors swung into action, and they were sophisticated. They had money. There's a fairly wealthy area. They had lawyers also. I think a couple of the neighbors were actually attorneys. One year I was talking smack about the property owners, and was like, that's my uncle. I was like, sorry. Like, maybe it was like her father or something. I was like, okay, I'm going to shut up now. But these were sophisticated people. And they use a number of different strategies to block construction. So initially they said that this would create a lot of traffic, and they wanted like a traffic study. And eventually the city said, no, not really. It won't really change traffic that much. And then they worried about noise and making all this noise. And they said, no, there are ways of mitigating noise. Right? You build a garage underground. There are things you can do. Eventually the city cleared for construction. Right? The lot was clear, ready to start building. And at the last minute, the neighbors go to court and they seek a nuisance suit. And they seek an injunction to bar this site based on a nuisance. Now, what was the argument for a nuisance? It's not that it blocked sunlight, it wasn't that it made noise, all those things were already taken care of. They argue that a nuisance was defined as a property that's out of use, right? That doesn't fit in with the surrounding areas. Because this building would look different than everything else, it was a nuisance. Now, that's not a nuisance. I don't think that's a nuisance. I can't imagine that as a precedent. But if that were the case, then Houston would then have a backdoor zoning code, right? Because any out-of-use place becomes a nuisance, and neighbors can go to court to stop it, right? It would function equivalent to a zoning code, which we do not have. We cannot have by city ordinance. The judge in that case did something weird, which I still don't fully appreciate, but I think I understand at least. The judge in that case said, well, yes, it is a nuisance, but I will not issue an injunction. Instead, I'll issue damages, right? I will award damages based on how much this diminishes the property values of nearby land. In other words, if this building decreases your property value by $10,000, making up a number, one-time damage payment. This is Boomer, right? The Boomer case, the cement mixing facility. You don't issue an injunction. Instead, you issue damages to compensate people for their loss of value. The case, I think, either settled or it's still going through the courts. I've lost track of it. It's so complicated. But the important point is actually how the litigants tried to use nuisance law to resemble zoning law, right? That an out-of-use building is a nuisance. And they're basically trying to mesh and mold nuisance law to fit what we don't have in Houston, which is zoning law. Now, I'm critical of these cases, why the girl who was uncle or whatever, she got mad at me. But at least the neighbors here had the means to do this, right? If this happened in another neighborhood, you wouldn't have that possibility because it's expensive. They spent a lot of money on lawyers and signs and websites and all this other stuff. StopAshbyHighrise.org. The website still even work? I don't even know. StopAshbyHighrise.org. Let's see. There it is. Oh boy. The last update's in 2014, so you see how long things have been going on for. A joint effort. I'm sorry?
The amicus brief.
Yeah, it was not by me, that's for sure. Hugh Rice Kelly. I don't even know who that is. Who's
I've heard the
Hugh?
name before.
Hugh Rice Kelly.
It's here in Harris
I don't know who this guy is. Okay, whatever. Anyway, you can scroll through the website later. Oh, God, this site goes on forever. Okay. Questions on the Ashby situation? Okay. Let me give a summary, and I'll give you a preview for class on Tuesday. Next week, we continue our discussion of zoning. And we consider what are called non-conforming uses. A non-conforming use. Right? What's a non-conforming use? You've been using your property for a long time, and the government says, aha, we are changing the zoning for your land, right? You could have industrial there, now it's residential, right? What happens when the government changes how your land's used retroactively? We also talk about variances, which are the hardship-based exceptions, as well as special exceptions, which are based on statute. Okay. Any questions? All right, I'll be in my office today by 3 or so, maybe 3:30. If you want to come by, please do. Otherwise, I'll see you next week. Thank you so much.